courts, not the government, will decide whether or not to use a new proposed law to hold offenders of serious sexual or violent crimes indefinitely. Well, Law and Home Affairs Minister Shanmugam also clarified to reporters that it's not a given that offenders will be jailed for unspecified periods. Parliament will debate the new proposed sentence for enhanced public protection, or SEPP, under the Criminal Procedure Bill next week. Lauren Ong with a report.
Cases of serious sexual and violent crime offenders reoffending are few, but for authorities, they're one too many. Hence, the Law and Home Affairs ministries see the need for stronger sentencing laws, such as the proposed SEPP.
When the person is first convicted, the court can choose to impose either the normal sentence or an SEPP sentence. If a court decides that this is a suitable case for enhanced public protection sentence, then you serve a minimum period. At the end of the minimum period, you are considered assessed by experts. And if you are no longer posing a high risk to society, you can be released. But if you still pose a high risk, then you can continue to be detained, and your case will be reviewed every year.
When asked if this effectively allows the government to overrule the judge's initial sentence, Mr. Shanmugam stresses it's for the court to decide if it takes the SEPP option or not. Some lawyers agree.
I think the review process, together with the sentence, without the remission, ensures that the accused person's rights to certainty in terms of how he's going to be punished is balanced against the protection to public safety.
Also, offenders may not necessarily face longer jail terms under SEPP.
With SEPP, the judge who is imposing the sentence would have greater clarity and greater, I would say, peace of mind, because he can impose what he thinks is a shorter sentence, knowing that at the end of that minimum duration, the offender can be released depending on whether he is rehabilitated, or experts will assess whether he is still a risk. So actually, it might provide for people to come out earlier.
The word I like to use is the appropriate sentence, because at the end of the day, if there's an assessment by the prosecution or the state, I think this SEPP legislation takes that into consideration, which is why the starting range starts with a fairly high sentence.
Still, some lawyers have their concerns.
As a criminal lawyer, I feel the mechanism needed to ensure that there are proper safeguards is one which involves a thorough review process before you want to keep a person longer than the sentence entails.
The ministry say the review will be done by an expert panel that's set to include the Detention Review Board, psychologists and psychiatrists.
It kind of adds validity to the assessment itself. It also possibly prevents people slipping through the net. And then, therefore, appropriate steps can be then taken to ensure that the person gets adequate treatment if he's suffering from a mental health condition.
Mr. Shanmugam says other proposed changes to the law will also give more clarity to criminal procedures and powers to officers. That includes allowing the police to conduct a search without warrant. He says these will better protect the public and ensure the guilty are brought to justice swiftly.